Hello, everyone, and welcome to Uncivil Law. I'm happy that all of you could join me on my channel tonight as we have some breaking and very unexpected news. An apparent leaked opinion from the United States Supreme Court, which appears to reverse both Roe and Casey. So this would overturn abortion law as it's existed since 1973 in the United States, if true. Now, I want to go through a whole bunch of stuff in introduction so that we can properly understand the context of this case, because this is really, really unusual. The last time there was a leaked opinion from the U.S. Supreme Court was 45 years ago. The Supreme Court just doesn't leak, ever. So the fact there's a leaked opinion is unbelievably notable, because it just doesn't happen. The second thing we're going to note is that this is a draft opinion, and nothing is final until it's issued by the United States Supreme Court. They can change their votes literally up to the last minute if they want and change their opinion. So this is not a final opinion, nor is it necessarily the majority opinion, nor even if it is the majority opinion, will it read like this, because other people will have had their input along the way. Now, what I can tell you is what we have. We have an apparent draft opinion from Justice Alito, which that fact reveals a couple things that are interesting. Because here's how it works at the Supreme Court. The oral argument for this case was December the 1st. After the oral argument, they get into the conference room where only the judges are there, and they have their initial discussion on it. And the way it works is that they discuss it in reverse chronological order. So starting with the newest appointed member, they go in order of seniority, discussing the case until they wind up back with the Chief Justice, who of course by position has automatic first place of seniority. And then they vote in order of seniority. They vote backwards. And then, assuming that there's no more discussion to be had, they go off to write an initial opinion. Who writes the initial opinion? Well, the initial opinion is assigned by the most senior member of the majority, in terms of the majority decision, obviously. The most senior member of the majority determines who writes the majority decision. So Justice Alito is fourth in terms of seniority. He is outranked by Breyer, Thomas, and the Chief Justice. So what can we potentially infer from this? Well, we can potentially infer from this that this is likely, as it was drafted, a 5-4 opinion. It seems very unlikely to my mind the Chief Justice would be willing to overturn Roe versus Wade. He just doesn't think that way. In fact, somewhat notably, it has been speculated that up until the last minute, the Obamacare cases were going to be overturned. It was only due to a last-minute shift by the Chief Justice that we got the opinion we did, upholding Obamacare under taxing authority, but not under Congress authority. So the Chief Justice seems reluctant, for whatever reason, to engage in these big, kind of bold actions. It's just not his personality type. So I think the idea of the Chief Justice being in the majority is very unlikely, which would mean that Justice Thomas would have to be in the majority, because that's the only way you get to 5. It would have to be Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Those are the only people you have left, which means Justice Thomas would be the one choosing who writes the opinion. And it's interesting that it's Justice Alito apparently writing the opinion. I would have thought it would have been more likely to go to Justice Barrett, but, for obvious reasons in terms of the optics of the thing is the reason why. But for whatever reason, it appears Justice Thomas has chosen Justice Alito to write the first draft opinion, non-official opinion. So we're going to look at this draft unofficial opinion for whatever it teases out, because again, the last time this happened with a leaked opinion was 45 years ago. It just doesn't happen at the U.S. Supreme Court. So what we see is that this is a first draft that was circulated on February the 10th, 2022, which is a pretty good indication that whatever's issued by the U.S. Supreme Court will not be this. Because again, it's a first draft opinion. Assuming Justice Alito was assigned to write this opinion, which seems likely, this would be the opinion he wrote on his own. It would then be circulated among other justices who would have comments, critiques, additions, deletions, and so forth and so on as part of the consensus process. So whatever we can divine that it probably, almost certainly, will not read exactly as we're reading now. But we can divine that this is Justice Alito's attempt to find something that would, at least in his view, meet the 5 votes that he had. And again, he would have some idea about that, what that would look like because of the conference session. He knows what every person has expressed. So he's going to write something that hopefully respects their views, but it wouldn't be unheard of for opinions to change and even occasionally majorities to change as part of the process undergoes. Sometimes you see the majority become the minority. You see all kinds of things happen. So, we will take this with a huge grain of salt as to what it means going forward, but we will read it for whatever value it has because, again, it just never happens. So this is draft opinion written by Justice Alito, who writes the following draft opinion. Abortion presents a profound moral issue on which Americans hold sharply conflicting views. Some believe fervently that a human person comes into being at conception and that abortion ends an innocent life. Others feel just as strongly that any regulation of abortion invades a woman's right to control her own body and prevents women from achieving full equality. Still others in a third group think that abortion should be allowed under some, but not all circumstances, and those within this group hold a variety of views about the particular restrictions that should be imposed. For the first 185 years after the adoption of the Constitution, each state was permitted to address this issue in accordance with the views of its citizens, which is generally true when it comes to pretty much all health regulation, incidentally, because health issues have traditionally been the province of state-level authority. All health issues, like even quarantining issues and stuff, are the issues of state-level authority, and we've seen that come out to play at least a little bit as we've seen the interplay with COVID in terms of how that works with state-level authority. But yeah, starting at the beginning, the health issues were matters of state, not federal government. Then, in 1973, this court decided Roe versus Wade. Even though the Constitution makes no mention of abortion, the court held that it confers a broad right to obtain one. It did not claim that American law or the common law had ever recognized such a right, and its survey of history ranged from constitutionally irrelevant, for example, its discussion of abortion in antiquity, to the plainly incorrect, for example, its assertions that abortion was probably never a crime under the common law. After cataloging a wealth of other information have no bearing on the meaning of the Constitution, the opinion concluded with a numbered set of rules, much like those that might be found in a statute enacted by a legislature. Under this scheme, each trimester of pregnancy was regulated differently. We're going back to Roe, by the way, on this one, in terms of when they're talking about this. So just a brief note, Roe versus Wade is the case that set up the trimester framework. So under Roe versus Wade, the trimester framework, abortion was always permitted in the first trimester, could be regulated in the second, could be forbidden in the third. That was Roe versus Wade, 1973. And then Casey came along in 1992 and changed it from a trimester framework to viability. So viability was the new line instead of the 3-part standard of Roe. So just by way of example, in case you're confused, Roe dealt with trimesters. Casey set a new line at viability. Before viability, it could be regulated. After viability, it could be banned by the state. That was Casey. Okay, so under Roe, each trimester of pregnancy was regulated differently, but the most critical line was drawn at roughly the end of the second trimester, which at that time corresponded to the point at which a fetus was thought to achieve viability. This is true, incidentally, in Roe versus Wade. The end of the second trimester and viability were kind of treated as synonymous, which became increasingly problematic as medical technology evolved, which is part of the reason that viability was completely detached from the trimester framework in Casey. Viability would be the ability to survive outside the womb. Although the court acknowledged that states had a legitimate interest in protecting potential life, it found this interest could not justify any restriction on pre-viability abortions. Regulations, yes, but not restrictions. That was what it said. The court did not explain the basis for this line, and even abortion supporters have found it hard to defend Roe's reasoning. This is true, incidentally, including Ruth Bader Ginsburg, who somewhat famously had difficulty defending Roe within its own constitutional framework. So there have been issues in terms of defending it within the constitutional framework that's defined. Yeah. Okay, hold on. Although the court, where was I? Although the court acknowledged, okay, I read that. One prominent constitutional scholar wrote he would vote for statute very much like the one court ended up drafting if he was a legislator. But the assessment of Roe was memorable and brutal. Roe was not a constitutional law at all and gave almost no sense of an obligation of trying to be. I mean, there have been definitely many criticisms of Roe written along these lines, to be sure. Great. Let's continue on. At the time of Roe, 30 states still prohibited abortion at all stages. In the years prior to that decision, about a third of states had liberalized their laws, but Roe abruptly ended the political process. It imposed the same highly restrictive regime in the entire nation and effectively struck down the abortion law of every single state. As Justice Byron White aptly put it in his dissent, the decision represented the exercise of raw judicial power and sparked a national controversy that has embittered our political culture for half a century. Eventually, in Planned Parenthood versus Casey, the court revisited Roe, but the members of the split three different ways. So Casey versus Planned Parenthood was a very split opinion, which was incredibly unfortunate because it made it very hard to administer, as pretty much all split opinions are. A split opinion, by the way, is where you have no opinion that commands 5 votes. So you have 5 votes or more for a result, but you don't have 5 votes for any particular opinion, which makes it very, very difficult for lower courts to administer because they're not quite sure what the U.S. Supreme Court wants them to do. So Casey versus Planned Parenthood had this flaw that it was one of these fractured vote decisions with no majority. And then, of course, the courts applying it ran into problems, which is very typical. 2 justices expressed no desire to change Roe in any way. 4 others wanted to overrule the decision in its entirety. And 3 remaining justices who jointly signaled the controlling opinion took a third option. Their opinion did not endorse Roe's reasoning, and even hinted that one or more of its authors might have reservations about whether the Constitution might have protected the right to an abortion. But the opinion concluded that stare decisis, which is the principle a thing decided, so once a court renders an opinion, that is the opinion, stare decisis, commanded stare decisis, which calls for prior decisions to be followed in most instances, required adherence to what it called Roe's central holding. A state may not constitutionally protect fetal life before viability, even if that holding was wrong. Anything less, the opinion claimed, would undermine respect for this court and for the rule of law. I mean, yes, to be sure, and Justice O'Connor in that same decision gave a very good concurrence in which she laid at least out what she thought were grounds for legitimately overturning Supreme Court decisions, which, to be honest, is as good as anyone else has written. So if you're interested on what the best writing is on the philosophy of when the Supreme Court should overturn itself, I can think of no better opinion than Justice O'Connor's in Casey, which did the best work, if, perhaps incomplete, but no one's done it better. Paradoxically, the court in Casey did a fair amount of overruling. Several important abortion decisions were overruled in total, and Roe itself was overruled in part. Casey threw out the trimester scheme and substituted a new rule of uncertain origin in which states were forbidden to adopt any regulation that imposed an undue burden on a woman's right to have an abortion. The decision provided no clear guidance about the difference between a due and undue burden. This has been a bit of a problem in interpreting Casey, yeah. But 3 justices who authored the controlling opinion called the contending sides of the national controversy to end their national division by treating the court's decision as the final settlement of the question of the right of abortion. Yeah, not so much. As it became increasingly apparent in the intervening years, Casey did not achieve that goal. That definitely cannot be denied. Casey did not put to rest the controversy, nor will this decision, I'm sure. Americans constitute to hold passionate and widely divergent views on abortion, and state legislatures have acted accordingly. Some have recently enacted laws allowing abortion with few restrictions at all stages of pregnancy, up to the moment of birth, incidentally, and potentially beyond that, depending on what some state legislatures are trying to do. Others have tightly restricted abortion beginning well before viability. And in this case, 26 states have expressly asked this court to overrule Rule and Casey and allow the states to regulate or prohibit pre-viability abortions. Before us now is one such law. The state of Mississippi asks us to uphold the constitutionality of a law that generally prohibits an abortion after the 15th week of pregnancy, several weeks before the point at which a fetus is now regarded as viable. This is fair. I think the all-time record right now for viability in terms of a birth surviving is somewhere around 20 weeks, maybe a little bit more, 20 weeks in some days. But yeah, 15 days is not within the current possibilities of medical science, but you never know, maybe someday. In defending the law, the state's primary argument is that we should reconsider and overrule Roe and Casey and once again allow each state to regulate abortion as its citizens wish. On the other side, respondents and the Solicitor General of the United States ask us to reaffirm Casey and Roe, and they contend that Mississippi law cannot stand if we do so. That's true. Allowing Mississippi to prohibit abortions after 15 weeks of pregnancy, they argue, would be no different than overruling Roe and Casey entirely. Well, at least Casey, sure. You don't necessarily have to overrule Roe. You could modify Roe again. So you could go back to the central holding of Roe and just amend it. But you'd have to toss out Casey for sure. Okay. They contend that no half measures are available, and we must either reaffirm or overrule Roe versus Casey. And then here's the line you all came for. Here's the moneymaker line. We hold that Roe and Casey must be overruled. Well, they're not hiding the ball, are they? They're being pretty clear. They're being really, really, really clear. In this draft opinion, draft, unofficial, might change, might not represent the majority, may not contain this line, but at least in the draft, they're not hiding the ball. They say it explicitly. Roe and Casey are gone. Okay, moving on. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. This does seem to be more in line with also what the Ninth Amendment was talking about, incidentally, which says this explicitly, right? Just because we mention some rights doesn't mean there aren't other rights. What other rights would there be? The ones that would be well built into common law. The ones that would be well essential to ordered liberty. For example, the general right to move between states freely would be an example. And that's been found to be implicit in the Constitution, even though it's not mentioned, because it's one of those things that the Constitution is held to talk about, which is fair enough because the right to travel is, within the common law. So, okay. The right to abortion does not fall within this category. Until the latter part of the 20th century, such a right was entirely unknown in American law. Indeed, when the 14th Amendment was adopted, 3/4 of states made abortion a crime at all stages of pregnancy. The abortion right is also critically different from any other right. this court has held to fall within the 14th Amendment's protection of liberty. Now, in case you're curious why they're talking about the law at the time of the 14th Amendment, this is where they think the right extends from. It must be the 14th Amendment, because that would be the one that controls states. No state shall deprive, right? And so what does the 14th Amendment mean? Well, you can obviously look at the words. And one of the other things you can do to interpret the 14th Amendment, or for any amendment for that matter, is to look at what the legislature was doing, both before and in the aftermath of the constitutional right. That helps you understand what the right was meant to include. It's not an absolute guide, but the idea is that as you are closer to the date of the amendment, and the legislation activity that is within, some time frame before and after, probably, all things being equal, reflects what the amendment was thought to mean. So if 3/4 of states didn't have a right to an abortion when the 14th Amendment was adopted, that might be some indication that that was not considered to be within the 14th Amendment's guarantee. This is how an originalist, for example, does interpretation. Not only by the text, but also the context of the time, which helps inform the original understanding of the words. So that makes sense from an originalist perspective, which of course Alito is. The abortion right is also critically different from any other right the court has held to fall within the 14th Amendment's protection of liberty. Roe's defenders characterize the abortion right as similar to rights recognized in past decisions involving such matters as intimate sexual relationships, contraception, and marriage. But abortion is fundamentally different, as both Roe and Casey acknowledge, because it destroys what those decisions called fetal life and what the law now before us describes as an unborn human being. Stare decisis, the doctrine on which Casey's controlling opinion was based, does not compel unending adherence to Roe's abuse of judicial authority. Again, this is very strong language from Alito. And I would be a bit amazed if the language is this strong in whatever final opinion there is. This is pretty strong language for the Supreme Court. I'm not saying it's impossible. I'm just saying I wouldn't bet on it. Roe was egregiously wrong from the start. I wouldn't bet on that either. Its reasoning was exceptionally weak, and the decision has had damaging consequences. Ditto. And far from bringing about a national settlement of abortion issues, Roe and Casey have inflamed the debate and deepened division. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives. The permissibility of abortion and the limitations upon it are to be resolved, like most important questions in our democracy, by citizens trying to persuade one another and then voting. That is what the Constitution and the rule of law demand. Well, that's basically the central holding. I guess we can keep reading, and we won't read, I guess, in full, because we don't really need to go through all the history and stuff, because we kind of have an idea of what that looks like. But we just read basically the holding, or at least the proposed holding of the court, proposed decisions of the court. The degree to which, it is or is not binding, again, is still an open question. Eledian asks, has something like this ever leaked before? It's been 45 years since anything's leaked from the court. It's been 45 years since anything's leaked. But that being said, this is a Supreme Court draft opinion. I've read enough opinions. I've read enough Alito opinions. This is authentic. This is an authentic draft. So again, it's possible this will be the language. It's possible none of this will be the language. It's possible it will be replaced in part or in total by completely different language as part of the drafting process. It's possible this will be a dissenting opinion in the majority as the votes change. There's a lot of potential things that could happen here. So, take it with a very big grain of salt. And this language does seem a little aggressive for the Supreme Court. So, again, I would be a bit shocked if they're this aggressive in their final decision. So, probably will tone some of that down, I would guess. Okay. So we can skip the history of the Mississippi Act, because do we really care? Not very much, because it doesn't really matter, because we're overturning Roe and Casey, so kind of who cares? All right, so we'll skip all the history of this particular lawsuit, because it doesn't matter. We'll begin by considering the critical question of whether the Constitution, properly understood, confers a right to obtain an abortion. Skipping over that question, the controlling opinion in Casey reaffirmed Roe's central holding, based solely on the doctrine of stare decisis. So it didn't purport, apparently, at least according to Alito, didn't even try to justify Roe, except to say, but it was decided though, which, is not necessarily the greatest anchor for stare decisis. Yeah. But as we'll explain, proper application of stare decisis required an assessment of the strength of the grounds on which Roe was based. We therefore turn to the question that Casey's plurality did not consider, and we address that question in 3 steps. First, we explain the standard that our cases have used in determining whether the 14th Amendment references to liberty protects a particular right. Second, we examine whether the right at issue in this case is rooted in our nation's history and tradition, and whether it's an essential component of what we've described as an ordered liberty. Finally, we consider whether a right to obtain abortion is supported by other precedent. Constitutional analysis must begin with the language, so it's a good place to start, which offers a fixed standard for ascertaining what our founding documents means. This is true. I mean, for better or worse, the words on the page don't change, so there's something we can always go to. And always a great starting point for the originalists, and potentially an ending point for the textualists, but that's another discussion for another time. The Constitution makes no express reference to a right to obtain abortion, and therefore, to those who claim it protects such a right, must show the right is somehow implicit in the constitutional text. Roe, however, was remarkably loose in the treatment of the constitutional text. It held the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned. Penumbras, man. Penumbras. And that privacy right, Roe observed, has been found to spring from no fewer than 5 different constitutional protections: the 1st, 4th, 5th, 9th, and 14th Amendments. This is a fair characterization. This is a fair characterization of the sort of consensus opinion about Roe in terms of its jurisprudential, bona fides. Again, a lot of people think it should stand for stare decisis reasons. But as I noted, even Justice Ginsburg had difficulty justifying Roe under its own terms, because this is correct. The abortion right was found in a right of privacy, which is also not explicitly mentioned, and was called the penumbra, or the shadow, of these combination of rights. So, not necessarily the greatest footing of all time in terms of its, The court's discussion left open at least 3 ways in which some combination of these provisions could protect the abortion right. One possibility was the right was founded in the 9th Amendment's reservation of the rights of the people. Exactly so, right? The 9th Amendment says exactly this. Just because we mention some rights doesn't mean that there aren't other rights. Yeah. Another was that the right was rooted in the 1st, 4th, or 5th Amendments, or some combination, and that this right had been incorporated into the Due Process Clause of the 14th Amendment, just as many other Bill of Rights provisions. So under this analysis, by the way, that would mean that abortion always was a federal guarantee. That would be what that would mean. Because the 14th Amendment is what does incorporation. Incorporation, by the way, is the process of applying the Bill of Rights against the states. Before the 14th Amendment, the Bill of Rights did not apply to the states. It only applied to the federal government, which means that all the Second Amendment enthusiasts out there, for example, the Second Amendment only applied to the federal government, which meant that at the beginning, it didn't apply to states, so therefore a state could pass any gun regulation it wanted because it wasn't bound by the Second Amendment. Also, incidentally, it means that states could found their own official church because they weren't bound by the First Amendment, because it only applied against the federal government. The 14th Amendment, though, changed that. That was kind of its point. And then we have to decide which of the constitutional guarantees are in the 14th Amendment. And in order to do that, we've had to go line by line in the Bill of Rights, every one of them separately. Each provision of the Constitution, Bill of Rights, there is a case somewhere that says it does or does not apply, with the notable exception of the Third Amendment dealing with the quartering of troops. Not so much case law on that, and I think there might be one other one that hasn't been dealt with, but I can't remember. So, whatever. And I believe the right to the jury trial for $20 was held not to be incorporated, but the rest were held to be incorporated. So there's a brief little history. So what that would mean, incidentally, as I was going back to my earlier thought, is if it was in the 9th Amendment, or if it was in some combination of the First, Fourth, and Fifth Amendments, that would necessarily mean that the federal government was unable to pass any abortion regulation from the very founding of the country, or at least since the Constitution, since the amendments were adopted. So close enough. So, all right. The third path was the First, Fourth, and Fifth Amendments played no role, and the right was simply a component of liberty. So in this conception, when they wrote liberty, they were creating something new. Rather than just referencing the old, life, liberty, and property, rather than just referencing the old, when they wrote liberty in the 14th Amendment, they meant to expand its conception. And so it's okay that it's not found in the First or Ninth or Fifth Amendments. That's okay, because when they wrote liberty, one of the things they meant by liberty was abortion. That would be the idea. So that's one of the things they meant to include in that word. Okay. Yeah. Roe expressed the feeling the 14th Amendment was the provision that did the work, but its message seemed to be that the right could be found somewhere in the Constitution, and specifying its exact location was not of paramount importance. Again, this is unfortunately a fair characterization of Roe. If you go read it sometime, it's, leaves a little bit to be desired on the jurisprudential front. Didn't really narrow down where in the Constitution it was coming from. They talked about penumbras, the shadows of amendments. It's in the shadows. This, not particularly encouraging language from the Supreme Court. Ginsburg herself agreed. But you could argue it should still exist for, stare decisis reasons, but, trying to find it in, the Constitution a little bit. Yeah. The Casey court did not defend this unfocused analysis, instead grounded its decision solely on the theory the right to obtain abortion is part of the liberty protected by the 14th Amendment. Okay. We discussed this theory in depth below, but before doing so, we briefly address one additional constitutional provision that some of respondents' amici have now offered as yet another potential home for the abortion right. The 14th Amendment's Equal Protection Clause. Okay. Neither Roe nor Casey saw fit to invoke this theory, and squarely foreclosed by our precedent, which established a state regulation of abortion is not a sex-based classification, and thus is not subject to heightened scrutiny that applies to such classifications. The regulation of a medical procedure that only one sex can undergo does not trigger heightened constitutional scrutiny, unless the regulation is a mere pretext designed to effect an invidious discrimination against members of one sex or the other. And as the court has stated, the goal of preventing abortions does not constitute invidious discriminatory animus against women, and they cite precedent for that proposition, incidentally. Accordingly, laws regulating or prohibiting abortion are not subject to heightened scrutiny, rather governed by the same standard of review as other health and safety measures, which for the most part would be rational basis, which is pretty low. With his new theory addressed, we turn to Casey's bold assertion. The abortion right is an aspect of liberty protected by the Due Process Clause of the 14th Amendment. Yeah, let's give that a shot. The underlying theory on which this argument rests is that the 14th Amendment's Due Process Clause provides substantive as well as procedural protections for liberty, long being controversial. Yeah, I mean, yeah, that's another problem, incidentally. If we want to go really hardcore on the whole originalism thing, this is something I've talked about before too, right? The entire concept of substantive due process is suspect. Now, it's not that big a deal because there was something that was going to do this work perfectly fine. It was called the Privileges or Immunities Clause. It was great. It was right there in the First Amendment. It was right there. No state shall deny the privileges or immunities. Great. It was right there in the text. It was great. What privileges and immunities? All those constitutional guarantees. It was fantastic. The Privileges and Immunities Clause was going to do all this work for us and bring in all those things. And then in a series of cases called the slaughterhouse cases, the Supreme Court radically narrowed the framework of the Privileges or Immunities Clause and basically nullified it. Pretty much. Supreme Court kind of nullified a constitutional provision. Kind of, sort of. Yeah. The Privileges or Immunities Clause was supposed to do this, and then he just kind of narrowed it to nothing in the slaughterhouse cases. And then, fast forward a little while later, and the Supreme Court's like, oh shit, the Bill of Rights is supposed to apply to the states. Now, what they could have done, which would have been great, was overturn the slaughterhouse cases. That would have been easy, right? But no, we can't do that because that would just be too easy. So we can't overturn slaughterhouse, so we can't find it in Privileges and Immunities. Okay, so what are we going to do? We're going to find that the word liberty, what that really means is the entire Bill of Rights. Now, what's problematic about that? What's problematic about that idea is that the Constitution says in the 14th Amendment, no person shall be deprived of life, liberty, or property without due process of law. So what does that imply? It implies that a person can be deprived of life, liberty, or property with due process of law. And at least in the case of property or life, we know this to be true. That would be like what, the death penalty is, and it would be what putting someone in prison it might be, and it is what the government taking your land for public use is going to be. That would be an example. But what we decided was, even though the Constitution says you can deprive someone of liberty with a due process, some liberties are so important you can't deprive them, even with due process. And we gave this entire conception a name, and we called it substantive due process. And then we incorporated all the Bill of Rights in this thing called substantive due process, which was completely unnecessary because we had the Privileges or Immunities Clause, which we decided to ignore. But that's the history of that. And then, of course, as we've been talking about, not only did the word liberty, it meant to incorporate the entire Bill of Rights, and also that they couldn't be deprived with due process, even though it suggests that they can, right there in the text. But also that it must necessarily include the right to an abortion, which that the word liberty was meant to encompass that, as well as the entire Bill of Rights, and perhaps other things. So you can see the problems. There are some problems. The underlying theory on which this argument rests, the 14th Amendment Due Process Clause provides substantive as well as procedural protection, has been controversial. But our decisions have held the Due Process Clause protects two categories of substantive rights. The first consists of rights guaranteed by the first 8 amendments. Those amendments originally applied only to the federal government, as I mentioned. But the court has held the Due Process Clause of the 14th Amendment incorporates the great majority of those rights and makes them equally applicable to states. Not so much with the Third Amendment and I think the $20 lawsuit thing. Oh, no, wait. The other one is a grand jury. I knew that. I knew that. Yeah, the right to a grand jury has not been incorporated by the states, against the states. I knew that. So not so much with the Third Amendment and not so much to the grand jury. Not incorporated. Okay, great. Moving on. The second category, which is one question here, compromises a set of fundamental rights that are not mentioned anywhere in the Constitution. In deciding whether a right falls into either of these categories, the court has long asked whether the right is deeply rooted in our history and tradition, and whether it's essential to our nation's scheme of ordered liberty. Timms versus Indiana. And then McDonald. Yeah, that's where I recognize the language from, was from McDonald. And conducting this inquiry, we've engaged in careful analysis of the history of the right at issue. Justice Ginsburg's opinion for the court in Timms is a recent example, in concluding that the Eighth Amendment protection against excess fines is fundamental to our scheme of ordered liberty and deeply rooted in this nation's history and tradition. Her opinion traced right back to the Magna Carta and 35 of 37 state constitutions in effect at the time. That's the kind of thing you're looking for, right? It's in 35 of 30 state, 7 constitutions probably represents a fundamental right, or at least, there's good evidence for it. A similar inquiry was undertaken in McDonald, the gun rights case, which held the 14th Amendment protects the right to keep and bear arms. The lead opinion surveyed the origins of the Second Amendment, the debates in Congress about the adoption of the 14th Amendment, the state constitutions in effect when the amendment was ratified, at least 22 of 37 states protected the right to keep and bear arms, federal laws enacted during the same period, and other relevant events. Someone asked what stare decisis is. Stare decisis just means it's a thing decided. So stare decisis just means it literally just translates to a thing decided. So it's the principle that once a court reaches a decision, it shouldn't revisit a decision. It's kind of like a double jeopardy for criminal law, except not as strong because it isn't absolute. So in a double jeopardy, obviously once it attaches and once you have it, you don't undo it. But stare decisis is kind of a similar concept. It's the concept that once a court decides something, it should remain decided. Of course, that would also imply if you held stare decisis to an absolute principle, if you held it as an absolute, then that would require you to uphold, Dred Scott and require you to uphold Plessy and other decisions. So it's never thought to be an absolute. And then the question is, well, how much strength should you give it? And that's an entire discussion we don't have time for. Only then did our opinion conclude the framers and ratifiers of the 14th Amendment counted the right to keep and bear arms among those fundamental rights necessary to our system of ordered liberty. Timms and McDonald concern the question of whether the 14th Amendment protects rights that are expressly set out in the Constitution. Yes, in this case, the 8th Amendment and the 2nd Amendment. Whether those provisions are incorporated. Correct. And it would be anomalous if similar historical support were not required when a putative right is not mentioned anywhere in the Constitution. Thus, in Glucksberg, we held the Due Process Clause does not confer a right to assisted suicide. The court surveyed more than 700 years of Anglo-American common law tradition and made clear the fundamental right must be objective, deeply rooted in this nation's history and tradition. Yep, this is where we start citing cases from the 12th century, guys. This is how we roll. We roll deep and we start citing cases from the 12th century. Because that's how common law works. Like, if you want to know what a guaranteed right is, let's start consulting the common law. You want to know if something's a right? Let's consult, all of it. How about just all the common law? How about 700 years worth to figure out whether or not it's a right or not? Fun times. History inquiries of this nature are essential whenever we're asked to recognize a new component of liberty, protected by due process, because the term liberty alone provides little guidance. Liberty is a capacious term. As Lincoln once said, we all declare liberty, but in using the same word, we do not all mean the same thing. In a well-known essay, Isaiah Berlin reported the history of ideas had categorized more than 200 different senses in which the term had been used. Good times for sure. Excuse me 1 second. Need to change something real fast. There we go. Great. Okay. In interpreting what is meant by the 14th Amendment, references to liberty, we must guard against the natural human tendency to confuse what that amendment protects with our ardent views about liberty that should enjoy. Yes, like all provisions of the Constitution, they, at least to the originalists, must and should be understood in their original context. This is good. This is good. This is the kind of thing that, for example, prevents hate speech from being regulated, because hate speech is protected by the First Amendment. Because when the First Amendment was passed, it didn't include hate speech as a forbidden subject. The First Amendment did not recognize as protected libel, slander, defamation, fighting words, obscenity. But, those are exceptions that existed at common law. If you want to know why they're not in the First Amendment, again, let's go consult the 700 years. Never understood to include those things. Plenty of case law about that. No problem. Not part of the freedom of speech. Right. So, same thing with liberty, right? It's not what we might think is good speech or bad speech today, or even good liberty or bad liberty today, or even like what cruel and unusual punishment might mean today versus originally. So what did these provisions mean at the time? That's how we roll in constitutional analysis, at least if you're an originalist. That is why the court has long been reluctant to recognize that are not mentioned in the Constitution. Substantive due process has at times been a treacherous field for the court, and it sometimes led the court to usurp authority the Constitution entrusts to people's elected representatives. As the court cautioned, we must exercise the utmost care whenever we're asked to break new ground in this field, lest the liberty protected by the Due Process Clause be subtly transformed into policy preferences of the members of the court. This is also a problem, and I think something that the progressives tend to ignore, because history doesn't always flow in one direction, and rights and conceptions of rights don't always flow one way. So for like everyone in the progressives who thinks that terms like liberty should be expanded to include ideas like abortion, if it can expand to include that, if modern sensibilities are the right understanding, then that implies that liberty might not protect as much as it used to, might protect much less than it used to, depending on who holds power at any given time. It transforms what was a rock-solid guarantee into one that is more free-floating, and one that's dependent on a modern consensus, at which point, how much can you be baked into the Constitution, really? Whatever giveth, it taketh away. So if you give the power of liberty to expand, it can taketh with the ability to contract. So something to watch out for. On occasions when this court has ignored the appropriate limits imposed by respecting the teachings of history, it has fallen into free-willing judicial policymaking that has characterized discredited decisions such as Lochner. This court must not fall prey to any such unprincipled approach. Indeed, guided by history and tradition that map the essential elements or components of this nation's concept of ordered liberty, we must ask what the 14th Amendment means by the terms liberty. Someone asked, am I an originalist? I somewhat famously consider myself more of a textualist these days. And the difference, to my view, is the difference between Gorsuch's opinion in the gays in the workplace case versus Kavanaugh's opinions in the gays in the workplace case. So you remember that there was the case dealing with whether or not the Civil Rights Act, which among other things prevents discrimination on the basis of sex, did the term discrimination of sex include sexual orientation? And the originalists, such as Alito and Kavanaugh, said no. And Justice Gorsuch, who's what you might consider, or at least what I might consider more of a textualist, said yes. And I agreed with Justice Gorsuch. I thought it was a brilliant opinion. I agreed with him that the term sex did include the sexual orientation for the reasons he described in his own opinion. And so these days, to the extent there is a difference between the textualist and originalist, I consider myself a bit more textualist because of Justice Gorsuch's opinion in that case. It was brilliant. In my humble opinion, at least. When we engage in that inquiry in the present sense, the clear answer is the 14th Amendment does not protect the right to an abortion. Under the latter part of the 20th century, there's no support in American law for a constitutional right to obtain an abortion. Zero. None. Again, this seems like pretty aggressive language for a final Supreme Court decision. Not sure I would expect this level of aggression. No state constitutional provision had recognized such a right. Until a few years before Roe was handed down, no federal or state court had recognized such a right, nor had any scholarly treatise of which we're aware. And although law review articles are not recent about advocating new rights, the earliest article promoting a constitutional right to abortion that has come to our attention was published only a few years before Roe. Not only was there no support for such a constitutional right until shortly before Roe, but abortion had largely been a crime in every single state. At common law, abortion was criminal, at least in some stages of pregnancy, and was regarded as unlawful and could have very serious consequences at all stages. American law followed the common law until a wave of statutory restrictions in the 1800s expanded criminal liability for abortions. By the time of the adoption of the 14th Amendment, 3/4 of the states had made abortion a crime at any stage of pregnancy, and the remaining states would soon follow. So, some evidence potentially to suggest that the 14th Amendment does not include that. Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty analysis. It is therefore important to set the record straight. We begin at common law, under which abortion was a crime until at least after quickening. Now, this will be interesting. This is very interesting from a common law perspective, and I'm interested to see what the court does here. Because this is an interesting aspect, like the idea of life beginning at quickening, which incidentally, for those of you who are not familiar with the term, was when the baby starts moving in the womb. That's what quickening is, or when quickening occurs. And also, just as a little FYI of linguistics, quick also means living. Quick means living. So that's why the movie's called The Quick and the Dead. Because quick is a term for living, which comes from this idea of quickening, when you become living. So, a little history there too. So anyways, this was a point, for example, in which you couldn't execute a mother who was pregnant. You couldn't execute her once the baby was quick, because to kill her would be killing the living child inside of her. This is the idea of pleating your belly in capital offenses. And this is what threshold was when the baby started moving. So a little bit of history there. So there is a potential here, either here in this opinion or an eventual Supreme Court opinion. There's a potential for the Supreme Court to adopt quickening. Incidentally, this is also mirrored, by my understanding at least, and I'm by no means a scholar, but it's my understanding that this is also mirrored in Islamic law. Because I believe, if memory serves correctly, that Islamic law recognizes a baby as being a life at 40 days, which is based on a similar concept of quickening. So, just an FYI. So there's a possibility, at least, the court could say, at common law, abortion, whatever that would be, could be recognized before quickening. Which, then you have to go on to define, but there is something there that might allow the court to go that way. So just some notes. Okay. And they note here that occurs between the 16th and 18th week of pregnancy. Let's see, 16 times 7. How well can I do math in my head? Let's see, that's 70 times 70 plus 42, which is 116. So that'd be 116 days. So a little bit more than the Islamic law, about 3 times. The eminent common law authorities all describe abortion after quickening as criminal. Henry D. Bracton's 13th century treatise explained that if a person had struck a pregnant woman or given her a poison, whereby he caused an abortion, if the fetus is already formed and animated, and particularly if animated, homicide. 17th century treatises likewise assert that abortion of a quick child was murder if the child born alive, and a great misprison if the child dies in the body. Misprison referred to heinous offenses under a degree of felony. Two treatises by Sir Matthew Hale likewise described abortion of a quick child who died in the womb as a great crime and great misprison, great felony. And the writing near the time of the adoption of our Constitution, Blackstone explained that abortion of a quick child by ancient law of homicide or murder was a very heinous misdemeanor. English cases dating all the way back to the 13th century corroborate the treatise's statements that abortion was a crime. In 1732, for example, Eleanor Baer was convicted of destroying the fetus in the womb of another woman and thereby causing her to miscarry. For that crime and another misdemeanor, Baer was sentenced to 2 days in the pillory and 3 years of imprisonment. Although pre-quickening abortion was not itself considered homicide, it does not follow that abortion was permissible at common law, much less that abortion was a legal right. Okay, so this is the part where, this is an interesting aspect if he can make this transition work. Quite to the contrary, in the 1732 case mentioned above, the judge said of the charge of abortion, with no mention of quickening, that he never met with such a case so barbarous and unnatural. Similarly, in an indictment from 1602, which did not distinguish between pre-quickening and post-quickening abortion, described abortion as pernicious and against the peace of Our Lady the Queen, her crown, and her dignity. That the common law did not condone even pre-quickening abortions is confirmed by one might call the proto-felony murder rule. Ooh. Hale and Blackstone explained a way in which a pre-quickening abortion could rise to the level of homicide. Hale wrote that if a physician gave a woman with child a potion to cause an abortion and the woman died, it was murder because the potion was given unlawfully to destroy the child within her. As Blackstone explained, to murder a killing has to be done with the malice of forethought, either expressed or implied. In the case of an abortionist, Blackstone wrote, excuse me, in the case of, where was I? In the case of an abortion, Blackstone wrote, the law will imply malice for the same reasons it would imply malice if a person who intended to kill one person accidentally killed a different person, which is true in modern law. If you intend to kill someone and accidentally kill someone else, you're guilty of intending to kill the second person, with this classic example. If one shoots at person A and misses him, but kills person B, this is murder, because of the previous felonious intent, which the law transfers from one to the other. Intent follows the bullet, as they say. The same case where one lays poison for A, and B, against whom the person has no malicious intent, takes it. This is likewise murder. Intent follows the poison. So also if one gives a woman with child a medicine to procure abortion and operates so violently as to kill the woman, this is a murder in the person who gave it. I don't know the degree to which this is a fair characterization. I mean, I understand he's citing a few things, but again, this is a potential ground for a compromise, to the extent that someone's looking for one. So, because, I mean, with respect to Alito, right? I mean, let's just be honest, right? One indictment from 1602 and another indictment from 1730, and something from two judges' decisions which don't distinguish it, at least as to their text, but maybe it was understood, like they didn't mention it explicitly, but it was understood in the decision if you go read it. And maybe Blackstone is mischaracterizing it here. So I just, for whatever it's worth, I don't know the degree to which this is correct analysis. This might be mistaken analysis here. And I will just note that there's at least some potential for some sort of compromise ground if anyone is looking for it. So, moving on. Notably, Blackstone, like Hale, does not state this proto-felony murder rule require the woman be with quick child, only that she be with child. And it's revealing that Hale and Blackstone treated abortionists differently from other physicians or surgeons who cause the death of a patient without any intent of doing that patient any bodily hurt. These other physicians, even if unlicensed, would not be guilty of murder or manslaughter. And that would be true in the modern era too, presumably. But a physician performing an abortion would, precisely because his sin was an unlawful one. Yeah. In sum, although common law authorities differed on the severity of punishments for abortions committed at different points in pregnancy, none endorsed the practice. Moreover, we're aware of no common law case or authority, and the parties have not pointed to any that remotely suggests a positive right to procure an abortion at any stage of pregnancy. Well, again, for whatever it's worth, I personally think that everything should be legal unless it shouldn't be, by which I mean the default presumption should be for legal. That's what I mean by that phrase, right? The default presumption should be for legal. And, justifications for making things illegal usually aren't pretty hard. And if you go through the laws and you look at them, most of them, although certainly not all of them, in my opinion, can be justified in some sort of way, right? There's a reason to make it illegal. But then the question becomes, if this is a principle you agree with, everything should be legal unless not, then the common law doesn't necessarily need to expressly state it, right? It would just necessarily have to not make it criminal. And a few scant citations, doesn't quite necessarily do it for me. So I'm not sure I necessarily agree with Justice Alito's analysis. I'm not saying he's wrong, mind you, because I don't have really good authority to the contrary. But it is, at least in my view, open to valid critique, and I would be a bad legal reviewer if I didn't note that possibility. So that's what I'm doing. I'm noting the possibility that it's open to critique. In this country, the historical record is similar. The most important early American edition of Blackstone reported Blackstone's statement that abortion of a quick child was at least a heinous misdemeanor. And that edition also included Blackstone's disclosure of the proto-felony murder rule. Manuals for Justice of Peace printed in colonies in the 18th century. See, this is kind of where I lose the thread a little bit. Because by this point in history, right, we've gone past England. So if we're looking for something in common law, then when we're talking about things being printed in the colonies, then it's not really on point. Manuals for Justice of Peace printed in the colonies in the 18th century typically restated the common law rule in abortion, and some manuals repeated Hale and Blackstone statements that anyone who prescribed medication unlawful to destroy the child would be guilty of murder if the woman died. That doesn't make sense. That doesn't make sense. It can only be murder if it would be murder of the fetus, which they're not saying, right? This entire idea from Blackstone, let's be clear about what it's trying to do. All right, this entire analysis from Blackstone, let's be clear about what it's trying to do. It's trying to do transferred intent, which is recognized at law today the same as it's always been. This is common law through and through. As they say, I shoot at person A, intending to kill person A. I kill person B. I'm guilty of killing person B. I intend to poison person A. I leave the poison out for person A to consume. Person B consumes the poison. I'm guilty of poisoning person B. But what do you need? You need both a person A and a person B. Blackstone says, okay, if you give the poison to the mother and the mother dies, it's wrong. But your intent wasn't to kill the mother. That wasn't your goal. It wasn't your goal. Your intent was not to kill the mother. So this only works if you're intending to kill another person, namely the fetus, which Blackstone doesn't say, by the way. He doesn't say the fetus is a person. So it might be that Blackstone, who, by the way, is one of the most revered scholars ever, so let's just make that clear, as I'm about to contradict Blackstone, who's like king shit over here. So let's just be honest about that, as I'm about to contradict Blackstone. But he takes it as a given without saying it. And this slightly irritates the logician in me. It can only be murder of the mother if it was murder of the fetus. But he doesn't say anywhere in those treatises, it doesn't say that if the fetus dies, it's murder. At least as to the pre-quickening, he doesn't seem to say that. So Blackstone was wrong. There's a bold position for the day. The few cases available from the early colonial period corroborate that abortion was a crime. In Maryland in 1652, for example, indictment charged that a man murderously endeavored to destroy or murdered the child by him begotten in the womb. It doesn't say how old the child was or whether it's quick or not, and I think it's a mistake to assume it either way. The court doesn't say it was a quick child or a pre-quick child. They just say a child. Maybe it was a quick child. Maybe that was the problem and the court just never said it. I'm not going to assume it means one thing or the other by the court's absence. That's ridiculous. And in the 19th century, courts frequently explained the common law made abortion of a quick child a crime. I am sold on a quick child. I'm sold. You don't need to sell me on a quick child. You need to sell me on a non-quick child. And none of this is really doing it for me. And I think Alito's analysis is sloppy here. So I'm contradicting both Alito and Blackstone. Well, I just have my balls all the way out on the table today now, don't I? The original ground for drawing a distinction between pre- and post-quickening abortion is not entirely clear, but some have attributed the rule to difficulty of proving a pre-quickening fetus was alive. At the time, there was no scientific method for detecting pregnancy in its early stages, and thus, as one court put it in 1872, until the period of quickening, there's no evidence of life. And whatever may be said of the fetus, the law has fixed upon this period of gestation as the time in which the law is endowed with life. I mean, that's just... I mean, it just directly goes against Alito. Okay, it just goes against Alito. The law has fixed upon this period of gestation as the time which the child is endowed with right. Maybe it's because we couldn't figure out if it was live before or not. But either way, the legal result was, this is the time. This is the time. And does the change of the facts necessarily change the legal result? Well, not necessarily, because as we know from the U.S. Supreme Court's own guidance, we discussed this, for example, in the male draft case, and the men who wanted to get the women in the draft, right? We've established this. We've talked about this. Right? All the underpinnings of that legal decision that said women don't have to sign up for the draft, all the legal pinnings have completely evaporated. Does that mean that the rule set up by the Supreme Court is gone? Nope. Because the Supreme Court says only it can change the law. So even though all the logical underpinnings of it is gone, the law remains with no support. Because that's how they roll. So it's kind of similar here too as well, right? So it's like, well, the factual underpinnings have changed. Now we can detect when life begins. Does that necessarily change the legal result? Well, it certainly doesn't change it at common law. That's for damn sure. Because the common law is fixed. So, I mean, until the period of quickening, there's no evidence for life because fetal movements are the first clearly marked and well-defined evidence of life. Yeah. The Solicitor General offers a different explanation of the basis for quickening, namely, that before quickening, the common law did not regard a fetus as having a separate and independent existence. The Solicitor General might be right. In common law, the Solicitor General might be right. Incidentally, this wouldn't necessarily, by itself, require it being held as a right within the meaning of the Constitution, because common law can often be changed by statute. Like, for example, like what a tort is, for example, like what a conversion is. Or even like common law crimes, what a burglary is for that matter. The definition of burglary has expanded since common law. At common law, for it to be a burglary, it had to be someone's home, and you also had to enter the home at night. During the day, it's not a burglary. Nighttime it is. Welcome to common law, right? But the statutes changed that and said, hey, you know, what about like any time of day? And what about also maybe not just people's homes? So you might be able to modify it by statute, but let's be honest about what the common law does and does not say before we get into an analysis about whether or not we can change it or not. You know? That's what I'm saying. But the case on which the Solicitor General relies for this proposition also suggested the criminal law's quickening rule was out of step with the treatment of prenatal life in other areas of law, noting that to many purposes in reference to civil rights, an infant inventure, sa mare, is regarded as a person in being. Are you going to translate that for me, by the way? No, you're not? That's great, thanks. At any rate, the original ground for the quickening rule is of little importance. Is it, though? Is it? Because the rule was abandoned in the 19th century. Can it be? During that period, treatise writers and commentators criticized quickening distinction as neither in accord with the result of medical experience nor the principles of the common law. In 1803, the British Parliament made abortion a crime at all stages of pregnancy and authorized the imposition of severe punishment. Well, just because Britain did it doesn't mean we can, incidentally. Because, you know, when we split off and became our own country, that's kind of the time when we stopped following British's common law, you know, because we're our own country now. So I'm all thrilled and all that England in 18 whatever decided to make abortion at all stages of crime. I'm super thrilled about that, but that in no way can possibly influence my analysis about the American common law, because, you know, it happened after we became our own country. So super thrilled and all, but I don't care. There are several rights, incidentally, that this is a good principle for. Because the First Amendment, as I pointed out, comes from our own common law tradition. Because this was the law in Britain beforehand. This is the First Amendment, as we all know and understand it, not including the hate speech. Apologize. Let me do that. Let me try that again. Freedom of speech does include the hate speech. I meant exactly the opposite of what I said. Freedom of speech does include the hate speech, does not include the libel, slander, defamation, fighting words, obscenity, right? Because this is the common law. Hey, let's go look at 700 years of law. Yay, I'm thrilled. Hey, how about England today? How about England today? Do they have the same conception of freedom of speech as we did? Nope. No, they certainly don't. Does it, because England changed it, does it mean we can change it? Nope. Because England decided to change it after we became a different country. You see? And so their conception of freedom of speech may not be what it was for 700 years before that, but we're locked into that understanding, which, at least in my view, as to freedom of speech, is probably a good thing. So, you know, there's that. Apparently, someone said the translation means it means in the mother's womb. Thank you for the translation. I appreciate it. Moving back to the decision. Or draft decision. Draft decision. Where was I? Of 9 states that not yet criminalized abortion at all stage, all but one did at 1910. The trend in the territories would become the last 13 states was similar. All of them criminalized abortion at all stages. By the end of the 1950s, according to Roe, statutes in all but 4 states and District of Columbia prohibited abortion. This is true. At the time of Roe, only 4 states recognized abortion. I believe Alaska was one of them, which is kind of ironic. And I think Washington State was one of them. And I'm not so sure about the other two. But yeah, this is one of the problems of Roe. Like on a real politique level, not even a legal level, this is a problem. Like at the time Roe was decided, only 4 states allowed abortion. And then they said, how about the rest of the country too? Even if it was a good idea, it was way premature. It was not a decision the country was ready for. And because of that, it froze the argument in place. And we've been having the argument for 50 years. You know, if they hadn't made that decision, who knows what the politics would have known. We never got the chance to find out. "30 states still prohibited abortion at all stages except to save the life of the mother. And though Roe discerned a trend towards liberalization in about 1/3 of the states, those states still criminalized some abortions and regulated them more stringently than Roe would allow. In short, this court's opinion in Roe itself convincingly refutes the notion that abortion liberty is deeply rooted in history or tradition." Well, I'll agree with at least part of that. I'll agree with that it wasn't rooted at the time. It definitely was not rooted in 1973. That's for damn sure. I'll agree it wasn't rooted in this history's tradition in 1973. I'll agree it wasn't rooted in this country's tradition in the 19th century, in the 1800s, in that other case they were talking about. But if we're going all the way back, if we're going to common law, and we're talking about pre-1776, talking about pre-1791, you know, when the Bill of Rights was adopted, I'm not so sure. So, some weakness there in the analysis, in my view. Again, I'm not saying Alito is wrong. He might be right. But his opinion, in like the earlier stages of the opinion, where he's criticizing Roe, and discussing the problems with Roe, I mean, yeah. I mean, you'll be hard pressed to find a lot of people that would disagree with those technical points. There are people who think Roe should stand. But you'll be hard pressed to find, even on the left, people who will argue that Roe was in fact a constitutionally based decision. Because Alito's just right. It's like you can't get there. And his criticisms of Roe and his criticisms of Casey were right on point. And I said so. But his criticisms of this quickening thing, I'm a little bit more doubtful. And at least as long as we're going to go overrule Roe and Casey, I'd like to get it right. From a legal posture, I'd like to get it right. As long as we're doing the move of, you know, overturning Roe and Casey, I'd like to be making sure I'm getting it right. And while I can agree with his descriptions of Roe and Casey in the weaknesses of their decision, his common law analysis, at least in my mind, into this pre-quickening period is less persuasive. So, just, you know, want to be intellectually honest about that, as I always try to be. He might be right, though. I mean, he might be right. Maybe he has it. It's just, I don't know, it doesn't feel solid enough. Especially to the extent he's talking about things that are true in 1973. I mean, a little bit, who cares when we're talking about what was true at common law? Why am I not talking about 700 years? Why am I talking about 1973 and not talking about the 13th century? You know, it's a little bit, yeah. A little bit, yeah. Jeremy WM in chat says, if you're overturning bad law, why does it matter if you use good law to overturn it? Jeremy, that might be one of the worst questions I've ever heard in my life. Why, if you're overturning bad law, do you need good law to overturn it? Because if you're overturning bad law, you'd be doing it to replace it with good law. Because the premise is you don't like the bad law. The bad law is wrong because it's bad. Why do you need good law? So you have something to replace the bad law with. That's why. Otherwise, you're just replacing bad law with bad law. And how intellectually honest is that? The inescapable conclusion is the right to abortion is not deeply rooted in nation's history and traditions. On the contrary, an unbroken tradition of prohibiting abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973. The court in Roe could have said abortion exactly what Glucksberg said of assisted suicide. Attitudes towards abortion have changed since Bracton, but our laws have been consistently condensed and continue to prohibit the practice. And then they go on to how there's no, rebuttal to this historical evidence, which I'll just take as a given for the moment. The Solicitor General repeats Roe's claim that it's doubtful abortion was ever firmly established in common law crimes, even with respect to destruction of a quick fetus. But as we've seen, great common law authorities like Bracton, Koch, Hale, and Blackstone all wrote that post-quickening abortion was a crime, and a serious one at that. Yeah, but the logic of what Blackstone wrote doesn't quite follow. Moreover, Hale and Blackstone asserted even pre-quickening abortion was unlawful. As a result, the abortion was guilty of murder if the woman died in the attempt. What if the baby died in the attempt? This only makes sense if the baby dies in the attempt. Otherwise, you can't transfer the intent. This is the problem with Blackstone. It only makes sense if killing the baby was wrong. And they're not saying that. They're doing transferred intent without something to transfer it from. It's bizarre. Instead of following these authorities, Roe lightly relies on two articles who claim that Koch had intentionally misstated the common law because of his strong anti-abortion views. These articles have been discredited, and it's come to light that even some members of Jan Roe's legal team did not regard them as serious. Now, this much is true. Like, they did cite an article in Roe, and the article was, in fact, extensively discredited. So, they're not wrong about that. An internal memorandum characterized this author's work as donning the guise of impartial scholarship while advancing the proper ideological goals. Continued reliance is unsupportable. As to that article, I'd agree. The Solicitor General suggests that history supports an abortion right because common law's failure to criminalize abortion before quickening means at founding and for decades thereafter, women generally could terminate pregnancy, at least in its early stages. But this insistence on quickening was not universal. And regardless of the fact that many states in the late 18th and early 19th century, which might be too late for the analysis, or at least we have to have a discussion about it, when legislatures began to exercise their authority as centuries won on, no one, as far as we're aware, argued the laws they enacted violated a fundamental right. This would be a little bit like saying that if the states had violated the First Amendment for decades and decades and decades, that makes it totally okay. Or for that matter, that, for 90 years or something, Plessy versus Planned Parenthood was the law? Or Dred Scott, that because it went on for so long, it must be constitutional now? I don't know, man. That's not surprising since common law authorities have repeatedly condemned abortion and described it as an unlawful act without regard to whether it occurred before or after quickening. When? If you're talking post America founding, tries to dismiss the state statutes that were in fact by suggesting they were enacted for illegitimate reasons. Well, I don't really care about that aspect, so I'll skip that. Resort to this argument is a testament to lack of real historical support. That last argument, I'd agree, but the one before it, not so much. Here, the arguments about legislative motive is not even I don't care. There's ample review that passage of these laws instead was spurred on by sincere belief abortion kills a human being. Sure, one may disagree with this belief, but even Roe and Casey did not question the good faith of abortion opponents. and we see no reason to discount the significance of state laws and questions based on amici suggestions about legislative motive. Yeah, not so much on the motive. I agree with you, too. I agree with that. Instead of seriously presenting the argument that abortion has deep roots, supporters contend abortion is an integral part of a broader entrenched right. This is, again, is where, like, the abortion people just go completely off the logical rails. Like, they just go completely off the logical rails. This doesn't make any sense, right? So, like, you know, I'll criticize Alito for his art. I mean, I'm not criticizing it as hard because I haven't thought about it as long. I mean, Roe and Casey have been around forever. I've been thinking about them for a long time. I haven't really been thinking about this quickening argument that long. So I'm not really willing to just throw Alito right under the bus, but I'll say, well, I'm not so sure about this. But in the same breath, I'll criticize Alito for what seems like a weak and questionable quickening analysis, although he might be right, because I'm not willing to say he's not right because I don't know enough to just flat out contradict him. But in the same way I'm willing to criticize Alito in this part of the opinion, I'll turn right around and criticize the abortion proponents in what he's talking about here, because these arguments by the abortion proponents don't make any sense. Casey described a freedom to make intimate and personal choices that are central to personal dignity and autonomy. At the heart of liberty is the right to decide one's own concepts of existence, meaning of the universe, and the mystery of human life. That's from Roe, and it makes me want to gag. The court did not claim this broadly framed right is absolute, and no such claim would be plausible. While individuals are certainly free to think and say what they wish about existence, meaning the universe, and the mystery of human life, they're not always free to act in accordance with that. You think? Sorry, that was a bit more sarcastic than I intended to be. I'm sorry. Let me try again. License to act on the basis of such beliefs may correspond to one of many understandings of liberty, but it's certainly not ordered liberty. That's a technical term, by the way. Okay. Nor does the right to obtain abortion have sound basis in precedent. Casey relies on cases involving the right to marry a person of different race. Yes. Loving versus Virginia, the right to marry while in prison. Turner versus Safely, the right to obtain conception. Griswold versus Connecticut. Elson versus Barrett. Casey versus Carey versus Population Services International. The right to reside with relatives. Moore versus East Cleveland. The right to make decisions about education of one's children. Pierce versus Society of Sisters. Meyer versus Nebraska. Great case. The right not to be sterilized without consent. Shiner versus Oklahoma. And the right to be in certain circumstances not to undergo involuntary surgery, forced administration of drugs, or other substantially similar procedures. Wilson. Washington versus Harper. Robin versus California. Respondents and Solicitor General also rely on post-Casey decisions like Lawrence versus Texas, which is the right to engage in, gay sex, and Obergefell, the right to marry a person of the same sex. These attempts to justify abortion through appeals to broader rights of autonomy and define one's concept of existence prove too much. The criteria at high levels could license fundamental rights to illicit drug use, prostitution, and the like. None of these rights have any claim to deeply rooted history. I'll let the libertarians argue amongst themselves about the drug use, prostitution, and so forth. What sharply distinguishes the abortion right from rights recognized in cases in which Roe and Casey rely, something those decisions acknowledge. Abortion destroys what those decisions called potential life. Yeah. And what the law in this case regards as life of an unborn human being. None of these decisions cited by Roe and Casey involve critical moral questions posed by abortion. I mean, I don't know about that. I mean, a lot of those cases deal with moral issues, which are arguably at least comparable, but okay. In drawing the critical distinction between abortion and other rights, it's not necessary to dispute Casey's claim, which we accept for the sake of argument, that the specific practices of the state at the time of adoption of the 14th Amendment do not mark the outer limits of the sphere in which 14th Amendment protects. Abortion is nothing new. It's been addressed by lawmakers for centuries, and fundamental moral question it poses is ageless. Defendants in Roe and Casey do not claim that any new scientific learning calls for a different answer to underlying moral question, but they do contend that changes in society require the recognition of a constitutional right to obtain an abortion. Again, this is where I get right off the train. No, we're not going to use changes in society to just recognize a new right. That's garbage. We're not going to use changes in society's understanding, because what giveth, it taketh away. Society can go forwards and it can go backwards. If we're going to use changes in society to recognize rights, we can use changes in society to deny people rights. We can't go down that road. And at least in my humble opinion, when we're doing this constitutional analysis, we have to be true to whatever the Constitution says, for better or worse. This is part of the reason I'm critical of Alito's analysis on the quickening thing. It's possible he could be wrong and still the conclusion would allow you to change it. Because, again, just because something is recognized as common law doesn't necessarily imply it's a right or couldn't be changed, because things at common law have been changed. For example, as I mentioned, like the crime of burglary as being one example. That's been changed. Maybe not so much with the just at night part, right? So Alito could be wrong, and it still could be the case that you could say, well, this is common law that has to be changed. But still, you got to go through that analysis and make the case or not. You know? So, but this is why you got to be loyal to the text. This is why you got to find the right law. This is why you got to be honest to what the common law does and doesn't say. Because if you don't do this, if you're unanchored, if you're unmoored, you just wind up in the exact same problem, fundamentally. And, you know, you're no better off than you started. It's just then a question of whether you like the decision or not, right? And that can't be the right answer. You have to be willing to make decisions you don't like, or you're not a very good judge. It can't be, well, this is the decision, this is correct because I believe in it. If you're not willing to make decisions that you don't believe in, you're in the wrong game, in my view. Americans who believe abortion should be restricted press countervailing arguments about modern developments. They note attitudes about pregnancy of unmarried women have changed, that federal and state laws have banned discrimination on the basis of pregnancy, that leave for pregnancy and childbirth are now guaranteed, that costs of medical care associated with pregnancy are covered by insurance or government assistance, that state laws have increasingly adopted safe haven laws, which generally allow a woman to drop off babies anonymously, and a woman who puts her newborn up for adoption day has little reason to fear the baby will not find a suitable home. They also claim that many people now have a new appreciation for fetal life. Yeah, this can't work either, right? It can't be right. Can't be right. Can't do that either. Can't appeal to new understandings of the pro-choice side. Can't appeal to new understandings of the pro-life side. Can't do it. Can't do it. Gotta find what it was meant originally. If we're not doing that, we're not good originalists. Both sides make important policy arguments, but supporters must show the court has authority to weigh in those arguments, as opposed to the legislature. Exactly so. So we return the power to the people. And then they go through stare decisis, and they talk about why stare decisis does or does not stand. They go through the analysis, and, you know, decisions we've overruled, blah, blah, blah. Okay. They talk about Plessy explicitly. Roe was also wrong in deep. Wow, that's interesting. They talk about Plessy, and in the very next paragraph, they talk about Roe. I mean, damn. Not saying you're wrong, but damn, what a connection, right? You talk about Plessy, and in the very next breath, you talk about Roe. Oof. I'll get someone's attention in the morning. You know what I mean? Roe was on a collision course with the Constitution from the day it was decided, and Casey perpetuated its errors. Yeah, to some extent, yeah. The court short-circuited the democratic process by closing it to a large number of Americans who dissented. Yeah. Under our precedents, the quality of reasoning in prior cases has important bearing on whether it should be considered. Roe found the Constitution implicitly conferred a right to obtain an abortion, but failed to find ground in decision on its text, history, or precedent. It relied on an erroneous historical narrative. It devoted the great attention to and presumption, relied on matters that have no bearing of the meaning of the Constitution. It disregarded fundamental difference between precedents on which it relied and the questions before the court. It concocted an elaborate set of rules with different restrictions for each trimester, but did not explain how this veritable code could be teased out of the Constitution. Yeah, there's that. And the most important rule that states cannot protect fetal life prior to viability was never raised by any party, has never been plausibly explained. Roe's reasoning quickly drew scathing scholarship criticism, even from supporters of broad access to abortion. As I said, you'd be a little bit hard-pressed to find left-leaning scholars who will really, really find this rooted in the Constitution. Yeah. I mean, there's some, but yeah. The weaknesses of Roe's reasoning is well known. Without any grounding in text, history, or precedent, it imposes on the Constitution a detailed set of rules much like must be found in legislation. That definitely has that aspect to it, I can't deny. Dividing pregnancy into 3 trimesters, the court imposed special rules for each. Yeah, that's a good question, right? How in the hell are you getting a 3-part system out of the constitutional? Even assuming you get a right to an abortion out of the penumbra, where in the hell are you coming up with this, like, 3-part thing? You know, it's just... The elaborate scheme was the court's own brainchild. Neither party advocated for the trimester framework. Neither did any party or any amici argue that viability should mark the point in which regulatory authority should be confirmed. Yeah. Not only did the scheme resemble the work of a legislature, but the court made little effort to explain how these rules could be deduced from any sources on which the Constitution decisions are usually based. Yeah. Roe's failure to even note the overwhelming consensus of the laws in 1868 is striking. And much of what it said about the common law was simply wrong. Much of what it said was wrong. I agree. Much of what it said was wrong. There might be other things, but yeah, what Roe... Yeah. Blah, blah, blah. Blah, blah, blah. What Roe did not provide for was any cogent justification for the line it drew. Why, for example, does the state have no authority to regulate first trimester abortions for the purpose of protecting a woman's health? The court's only explanation was mortality rates for abortion at that stage were lower than mortality rates for childbirth. But the court did not explain why mortality rates were a factor the court could the state could legitimately consider. Yeah, why is that the factor? Many health and safety regulations aim to avoid adverse health consequences, and the court did not explain why it departed from the normal rule that courts defer to the judgment of legislature. Blah, blah, blah. The most obvious problem with any such argument is that viability is heavily dependent on factors that have nothing to do with characteristics of a fetus. One is the state of prenatal care at the time, at a particular point in time. I mean, that's kind of true for all medical technology to some degree, so okay. One is the state, due to the development of new equipment and improved practices, the viability line has changed over the years. Yes, but, you know, to be fair, so has, like, the line of what constitutes death. Also, our ability to, you know, our ability to essentially resurrect people who would have been considered dead because of new medical technology, right? We can now bring back people from the dead, at least that term would have been understood in the ancient times, to some degree because of the medical technology. So sure, medical technology has improved to move the line of viability. It's also moved to improve the line of death. So I'm not sure 100% what your point is on that, to be honest. In the 19th century, a fetus may not have been viable until the 23rd or 23rd week. Okay. All right, so now I understand your point. Now I get it. I don't agree with it, but at least now I get why you're doing it, right? Because you're saying, okay, let's assume that viability was the right metric. Then viability would have been the 32nd week, and maybe it was frozen at that forever, because that's how the Constitution works. So assuming it recognized viability as the standard, it would recognize viability it was then understood, now isn't now understood. That's why you're making the argument, but I think the entire idea of going to viability makes no sense. Quickening, as I noted, was also not based on viability, further making viability make no sense. Viability is not a hard and fast line. This is true. The viability line, which the Casey deemed Roe's central rule, makes no sense. It's telling that other countries almost uniformly eschew such a line. This is true. The U.S. is a bit of an aberration on this factor. Other countries said it differently, but we're one of the most liberal countries in the world when it comes to abortion. So, Roe's reasoning was exceedingly weak, and academic commentators, including those who agree with the decision as a matter of policy, were unsparing in their criticism. John Hart Ely famously wrote that Roe was not constitutional law and gave almost no sense of an obligation to try to be. Archibald Cox, who served as Solicitor General under President Kennedy, commented that Roe reads like a set of hospital rules and regulations, that neither historians, laymen, nor lawyer will have been persuaded are part of the Constitution. Lawrence Tribe, he's a big voice on the left. Lawrence Tribe, big boy on the left, wrote that even if there is a need to divide pregnancy into several segments with lines that clearly identify the limits of governmental power, interest balancing of the form the court pursues fails to justify any of the lines actually drawn. Mark Tushnet deemed Roe a totally unreasoned judicial opinion. Yeah, there's a lot of that. Yeah. And then talk about how Casey didn't really deal with it, which it didn't. Workability. Is the decision workable? We've seen problems with Casey for sure, because it was a fractured opinion. Casey is not workable. Again, maybe Roe could have been modified with something to replace Casey, but Casey was definitely not workable. Effect on other areas of law. Reliance. Yeah, reliance interest is kind of weak, because there's no one really with reliance interests. In Casey, the controlling opinion conceded that traditional reliance interests were not implicated because getting abortion is generally unplanned activity. Yeah, you can't really have a reliance interest on things that are unplanned. Doesn't quite, yeah. Unable to find reliance in conventional sense, the controlling opinion in Casey perceived a more intangible form of reliance. It wrote that people had organized intimate relationships and made choices that define their views of themselves and their places in society, and reliance on the availability of abortion in the event that contraception fails. And the ability of women to participate equally in economic and social life of the nation has been facilitated by their ability to control their reproductive lives. Yeah, that's what Casey said. But this court is ill-equipped to assess generalized assertions about the national psyche. Yeah. Our decision returns the issue of abortion to those legislative bodies and allows women on both sides of the abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislature, voting, and running for office. Women are not without electoral or political power. It is noteworthy that the percentage of women who register to vote and cast ballots is consistently higher than the percentage of men that do. Unable to show reliance on Roe and Casey, Solicitor General suggests overruling those decisions would threaten the court's precedent, holding that due process clause protects other rights, such as Griswold, which, is a bit of a fair criticism. That's not correct for the reasons already discussed. Your reasons already discussed are a little in unconvincing to maybe to know. They're a little bit unpersuasive. I don't I don't really buy the idea that Griswold is beyond assault. Griswold was the case that said that married people had the right to contraception, by the way. Griswold versus Connecticut. Connecticut at the time banned married people, and all people for that matter, from using contraception. Connecticut. Shows you how things changed. Griswold was what? It was in 1940s or 1930s. It wasn't that long before Roe. You know, and maybe it was 1950s. Nah, it probably wasn't that late. Maybe, but you know, yeah, it just shows you how much culture's changed. Like Connecticut banned everyone, including married people, from using contraception. And Griswold said no. Now, in the analysis here, they say, well, abortion is not like any of these other things. It's special because it threatens potential human life. And then you go to Griswold about, you know, conception, and you're like, are you sure that's not also true? Are you 100% sure that's true? It's not at least have some of the moral indications that Casey and Roe does? Are you sure you can fully separate Roe and Casey from Griswold? You know, not 100% on that one. There, be honest. Blah, blah, blah. Blah, blah, blah. We therefore hold the Constitution does not confer a right to abortion. Roe and Casey must be overruled, and authority of regulation must be returned to the people and the elected representatives. And then they go into what happens will govern state stuff. Do super chats, Stephanie says? Okay. Let me do some super chats since the beginning. Someone gave me a sticker that I can't quite read, but thank you for the sticker. Economath gave me $10. Dibs on calling this the dead clout decisions. Cute. Striker A says, cheers, Uncivil. Thanks for the analysis on this and all the other reviews you've done. Take care and thanks for all you do. You're welcome. Luigi 2K says $20. Thank you. The Real Zooch gives $10. Thank you. JM 499. Thank you. Sue Brubaker gave $10. Thank you. Sue Brubaker also became a new member. Thank you for becoming a new member of the channel. Stan Honeycock, when was the leak 45 years ago you referenced earlier? Hold on. I have it written down somewhere. Hold on. Talk amongst yourselves. It was... The Brethren. Which was... Hold on. Yeah, it was a book. The Brethren revealed some of that inside baseball shit. So that's, yeah, basically the last leak that really kind of happened. Bob Woodward book. I knew I had it in my notes somewhere. $5 from Dave Farlow. What are your opinions on the leak itself, not the actual content leak? Do you believe this will damage trust among the justices? I'll tell you what. Some clerk somewhere just gave up a huge career because the Supreme Court will absolutely do everything in its power to find out where this thing came from. They will put like every single one of those clerks under oath. Because a clerkship at the United States Supreme Court is a very big deal. It's a very big deal, and it's very lucrative. Not so much at the court itself, of course, but after the court. Law firms will pay a $250,000 bonus or more for a Supreme Court clerk. Just cash, just straight cash. They'll give you hundreds of thousands of dollars for a Supreme Court clerkship because of the prestige, because of the show of trust, right? Because to become a Supreme Court clerk, you have to be, well, you don't strictly have to be, but as a practical matter, you have to go through a court of appeals and a district court. You have to be entrusted by multiple different judges at different levels. And your writing and your ability to perform those jobs has been vetted and re-vetted. So, it's a pretty big deal. And, you'll get basically any job you want. coming out of the Supreme Court. Any law firm would be a fool to turn down a Supreme Court clerk. It's a guaranteed job anywhere, with bonuses, with high pay, with accelerated track. It's a way to get a professorship in a hurry. It's a way to get a judgeship in a hurry. It's a huge deal. So some clerk somewhere just forfeited their entire life. Because if they figure out who did this, not only will that clerk not get those things, they won't get anything. They will be disbarred for this. And I don't know if there's criminal penalties possible, but I bet you someone's going to take a real hard look at the U.S. Code. So there's that. It's a big ass deal. The rumors is saying it's one of Sodom Warriors clerks. I'll tell you what, if they figure out who, I think Sotomayor would burn them. I think Sotomayor would burn them. I think any of them would burn them. I think whoever did this is going down and going down hard. I think they will be disbarred, disgraced, and they'll be lucky to be working at a McDonald's. It's a big deal. Why does it have to be a clerk? Why not a justice? I mean, really? Seriously? Come on. Dave Farlow, $5. What are your opinions of legal? Okay, we did that. $9.99 from Samuel, 527. I truly don't understand stare decisis. Why should a judge defer to a previous decision they genuinely believe is unconstitutional? It's a fair point. Stare decisis itself is a common law concept, and we're a common law country with common law. The concept of stare decisis isn't something mentioned in the Constitution, but our entire legal tradition, including, like the Bill of Rights for that matter, are all common law traditions. And stare decisis is a common law tradition. That's the huge difference between common law and civil law. And I think for the better overall, because I think civil law is stupid. I think common law helps a lot to make law much more predictable, much more stable than civil law, which I think is a trash fire. But yeah, that's my view of the thing. It's a good thing in the large part. $2 from Eric Winberg. Go get him, Kurt. You are welcome. Lai Jaman says $20. Could Alito's strong language be intended in the draft to cement the decision agreeing on the agreeing judge's mind? Your guess is as good as mine, because this is some aggressive language. I can tell you for an absolute certainty, it's definitely not going to be what's issued, because of course, being the first draft opinion, it doesn't at all deal with what the dissent says, which of course the main opinion will. So, I mean, I already know it's not the final opinion for at least that reason. Unless, of course, there's no dissent. I mean, you don't have to answer the dissent if there is no dissent. So in the event that this is a 9-0 decision, I guess that, we could have the really strong language. So it just depends. Do you think that this is going to be a 9-0 decision or not? What do you guys think? I don't know. Maybe. $2 from Matt Bond. You dare question Blackstone? A little bit. He's, $1.99 from Julio, and suddenly Amazon's out of wire hangers. Funny. Ricardo Ospinilla says, becomes a member, or is member for 25 months. Thank you. $1.99 from Julie O. Same people who refused Max because it was their right. Maybe. But then again, people have the right to do stupid things. People have the right to be asses. So, fair. John O'Brien says, if you have a better attachment provided, I don't. I have what I have. $10 Wiki DIPR says, keep up the good work, Kurt. You're welcome. $1.99 from Law School is IIED. Cute. What are the chances a justice changes their vote? I mean, again, it's been known to happen. It happened, at least by rumor, because, again, the Supreme Court doesn't leak. So normally all we have is rumor and innuendo. But at least it was argued to have happened with Chief Justice Roberts in the Obamacare cases. It was rumored that, up until the last minute, they were going to overrule the decisions altogether. and then Justice Roberts changed sides. So what are the odds that's true here? I don't know, but I figured I'd at least alert you to the possibility. Maybe, you know, it could be 0 to 9. Of course, maybe it's possible that Alito will see a dissent memo and think to himself, you know what, I was wrong. You know, I was totally wrong about all this. I'm sure glad, you know, that isn't the final opinion of the court. You know, I'm definitely going to join Justice Sotomayor's majority 9-0 decision reaffirming Roe and Casey. That's a thing that could happen, theoretically. Maybe. Probably about the same odds as, you know, the 9-0 decision with Alito is the 9-0 decision written by Sotomayor. But, you know, it's possible. So, yeah. Gary Austin, too, says, thanks for being on this so quick. Nice pun, and you're welcome. $10 from Kyle Anderson. Fantastic points about making decision based on palatability. Exactly so. Can't do it. Can't do it. You cannot rule because you think, just because you think life is precious. You cannot do it just because you think life begins at conception. Can't do it. You can't do it. It's a mistake. It's a mistake, and you're no better off than the pro-choice side. You're just doing something because of your policy preferences. You think life begins at conception, and you're doing it just because of that. You're no better than the pro-choice side. The only thing to do is be principled about it. It's the only way to fly. What does the Constitution say? What does it support? What doesn't it support? What was recognized at common law? What wasn't recognized at common law? What about this quickening thing? And so forth and so on. The only way to be is principled, or don't be anything at all. They've named the clerk. If they're right, man, that clerk is done. If they're right, that clerk is absolutely 100% toast. They're done. They will be disbarred. They'll be lucky to be working at a Walmart. $19.99 Startup Lab. Great show, Kurt. Maybe you should be a legal ghostwriter for con law pleadings. Keep up the hard work. You're looking healthier these days. Why do I need to be a ghostwriter? I'm admitted before the U.S. Supreme Court. I can sign it on my own name. Why do I need to be a ghostwriter? I can sign it on my own name. Chapter 8, $10. Late to the party, but it's infuriating that certain justices have goaded voting rights and campaign finance laws, allowed gerrymandering, and then said, just vote if you don't like forced pregnancy. Well, I disagreed with the Supreme Court case. I disagreed with the Supreme Court in the voting rights case. I very strongly agreed with the Supreme Court in the campaign finance case. We've discussed what's it called? We discussed what's the campaign finance case? Damn. You hate it when it's brain fart, right? I don't have it, but I agreed with it. Citizens United, that was it. Citizens United finally came to me, thanks. I agreed with Citizens United, disagreed with them in the voting rights case. And the gerrymandering case, I agreed with them because of very technical reasons. You know? I think that's where I stand on all that. $4.99 from Michael Drum. Since the court hasn't voted yet on this case, do you think Roberts could throw out the case due to a leak? No. Absolutely not. $4.99 from Donna Cross. Mark my words, this hashtag leak is a setup by the left. The draft may not even be a final decision, but all the Dems going to force Schumer to nix the filibuster. Why? Why would they have to? They've already confirmed their justice. Zachary McPherson, A799. Excellent to go through it. I'm still an hour behind. As an Australian, I hope the pro-choice momentum goes global. Okay. $20 from Scott Baines. Whoever leaked this should be banned from Golden Corral for life. Word. E.E. Caroline, member for 4 months. Stan Honeycutt. I tell my students the exact same thing about the clerks, but I fear the left will elevate this person and they'll have a show on MSNBC by the end of the year. I don't know, man. I don't know. I think the Supreme Court is going to look to burn these people alive. Stephen Light, $9.99. How would they find the person who leaked it? The reporter won't give the person up. Well, you know, getting affidavits from literally all of them, making them swear under oath, getting the FBI involved, that's always fun. They have police of their own. They'll figure it out. There's not that many of them. There's not that many clerks. It's a short list. I'm V-Boss, $4.99. Unrelated, read later question. I heard you and Nate mention Gorsuch has a well-written opinion recently. Will you speak more on that in the future? I've spoken on it in the past. It's the gay rights case. It's the gay rights in the workplace case. I thought it was brilliant. It was the gay in the workplace case. Can you discriminate on the fact that someone is gay? And Gorsuch said no, and I thought it was brilliant. So it made me a Gorsuch fanboy, I'll tell you what. Tay Mao says, I saw people talking about the right to privacy earlier. Why were people thinking this would threaten that foundation? Because the right to privacy is also made up, just like the abortion is. There is no right to privacy. It doesn't exist. There's no generalized right to privacy. Someone has suggested a name. I'm not going to repeat it here. I don't know if it's true or not. Rob Price, member 2 months. Otto Rommel, great detailed analysis, thanks. Rick Nikita gave $5. Life begins when they'll give me the maximum amount of comedy. They can make everyone tell paragraphs. Yeah, take polygraphs. I'm not going to repeat the name here. Unless it's been confirmed by the Supreme Court. I'd confirm it if has it been confirmed by the Supreme Court who the name of the leak is? Because it's been confirmed by the Supreme Court, I'll report it. But, up till then, I'm not going to throw anyone under the bus. It's just too big. Yeah, it's just too big. Could have been a leak from the White House. Want to get a sneak peek? Absolutely not. No, it's all internal to the Supreme Court. The Supreme Court confirmed it? Pop-Tart, you're telling me the Supreme Court itself confirmed it? Shouldn't Sotomayor be impeached if it was her clerk? Only if she directed it. Not confirmed, yeah. I didn't think so. Roberts is calling in the FBI. I bet he is. I bet he is. I bet he is calling in the FBI. The FBI is going to tear this apart. The FBI is going to tear this apart. And if you are the clerk, man, just remember, you can't lie to the FBI, but you don't have to talk to them. So, if it's you, well, you might want to invoke your right to remain silent, but if literally no one else does, kind of narrows it down. So, you might be able to save yourself from criminal charges, but you are toast. The only way I think this could impact Sotomayor is if she directed it, which I can't believe that Sotomayor directed. I just don't believe it. I do not believe this is a Supreme Court justice. I don't believe it. I cannot believe that any member of the Supreme Court would do this. It's unthinkable. It's absolutely unthinkable. Let's go back to the decision. $4.99. Wait. $10 from Scott Baines. I can't imagine a worse method of figuring out who did it than involving the FBI. The FBI isn't always bad. The FBI can be very, very good at their jobs. So I would be pissing my pants if the FBI was involved. I'll tell you what. $4.99 from Ryan H. I know it's evil, but I can't help thinking abortion has kept people who get abortions from passing on their awful politics. Maybe. David Farrow, $5. Do you think the leaker will try to claim whistleblower protection? I don't think there's any whistleblower protection available. Whistleblower protection, to the extent it exists, is a creature of statute, and I don't believe there's any whistleblower protection that applies here. So, no. Rob Price says no one thought Nixon would have done Watergate. I mean, fair. Well, still. $4.99 from Rick Hasksaw. You underestimate the far left. The leaker in his mind is doing God's work. Someone might be going to prison over this. I don't know what statutes apply, but I'm telling you, they're going to find somebody. They're going to find somebody. And they're going to charge him with something. Rational basis standard is the appropriate standard for challenges. Well, you can just kind of stop reading there because rational basis is pretty hard to fuck up. Yeah. So how should we review what the state of Mississippi did? Rational basis. Which basically means Mississippi can do whatever the hell it wants. Rational basis is pretty hard to screw up. Yeah, I can stop reading. We must end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey abrogated this authority. We now overrule those decisions and return authority to the people. The judgment of the Fifth Circuit is reversed, and the case is remanded. Well, yeah. $4.99 from Johnny Stoffel. I felt a great disturbance in the force if millions of voices suddenly cried out in relief and were suddenly not silenced. Cute. I thought it was strict scrutiny. Well, not anymore now. Not anymore, it's not. That's the whole point of this decision. It's not anymore, right? Because once you say it's not a constitutional guarantee, which is the entire point of this analysis, right? Once you say it's not a constitutional guarantee, what's left? All right? If it were a constitutional guarantee, we'd be talking about strict scrutiny. We'd be talking about intermediate scrutiny. But it's not a constitutional guarantee. That is the entire point of this. So what's left? Rational basis. $2 from Rob Burgess. The Dems are going to Tupac this clerk. $10 from Jody Williams. Democrats are committing terrorism. That's exactly what this is. Trying to influence politics via violence. Maybe. So, $5. Doesn't there actually, from Jake, doesn't there have to actually be a crime and corresponding charge in order to invoke the Fifth? No, there just has to be criminal exposure. You don't have to have a formal charge. You just have to have criminal exposure. And I'm sure there's some criminal exposure here somewhere. But there does have to be a crime, or at least it has to imply the crime. So, has anyone leaked a SCOTUS decision before? Not in my memory. Not as long as I've been alive. It's not happened. It's not as live as I've been. I've actually shot. Steven says I'm actually shocked they got 5 votes to overturn this. They haven't. I've made this clear in the pinned comment. I made it clear in the description. They haven't. They haven't got 5 votes. It's a draft. It's a draft. The Supreme Court hasn't done anything yet. $5 from Chapter 8. If we're going with hyperbole, the side who have people murdered, abortion providers simply can't complain regarding the leaker thinking they're doing God's work. Depends what your view of God is, I guess. Misuse of governmental systems? I don't know what the charge will be, man. They'll find things. They'll charge them with something. Supreme Court was hacked. I doubt that very, very much. It's not happened ever. If it's ever happened, it hasn't happened within my memory. A leaked opinion. Sometimes you'll get like a leak. The closest you get to a leak is sometimes, and not that often, mind you, because the last time was 45 years ago. Maybe sometimes someone talks a little bit of inside baseball. You know, in terms of how the judges think, or times of their like internal processes. I don't know when, if ever, they've had a full fat opinion leak. Someone is going down, and someone is going down hard. Leaking this document, wouldn't that be covered under leaking sealed documents? I don't know. We'll just get pardoned. I wouldn't bank on it, man. I would not bank on it. $2 Australian from Matt Bond. Of course, the mainstream media is saying it's over. Yeah. Who regulates the PR of the Supreme Court? I'm not sure they do have anyone regulating the PR of the Supreme Court. I'm not sure there's a PR for the Supreme Court. Because they don't do PR. What crime would it be? I don't know, man. I don't know the U.S. Code back to front. But I tell you what, man. I will start skimming the U.S. Code and I'll find something to charge him with. I'll find something. I don't know what it is, but I will find something to charge him with in the U.S. Code. It's got to fall within the definition of son crime. Do you know how many federal crimes there are? It's a long list. If they use a computer in the leak, I'm sure it's a crime. Well, I don't think it's fraud. So computer fraud, wire fraud is out. Computer fraud is out. CFAA, maybe. Depending, but probably not because, well, first of all, we're assuming it came from a computer, which it could have been printed off, which this looks scanned in, so yeah. You have a public affairs office? Noted. All right. $5 from CNN sucks. Do you think that these leaks was to get Robert to change his vote? First of all, I think the odds that Roberts is already with the liberals is pretty good. I think this is a 5-4 decision. This does, okay, here's what I think. I don't think Roberts is in the majority. Assuming this represents a majority opinion, I don't think Roberts is in the majority. Because Roberts would never agree to this. Roberts might, on a good day, agree to overturn Casey. I don't think you can possibly squeeze a vote out of Roberts to overturn Roe. I just don't think that's something Roberts would do. So, I don't think Roberts is in the majority. I think it's 5-4. I think it's Thomas, Alito, Gorsuch, Kavanaugh, and Barrett is what I think. I don't think, because if this opinion is meant to reflect the sort of 5 votes they had coming out of the conference, this doesn't reflect the chief's views. And also, why, the chief gives it to Alito to write as opposed to keeping it, or there's no way Roberts is in the majority. There's no way. This is a 5-4. Justice Thomas is the most senior justice, which means that Thomas assigned it to Alito for whatever reason. Someone says they checked. This is the first time in history a Scottish leak has occurred with an opinion. I believe it. I believe this might be a first. I believe this could very well be a first. The Supreme Court just doesn't leak. Ever. This might very well be the first time this has ever happened with a leaked opinion. I can't think of anything in history that even comes close. The Supreme Court just doesn't leak. Maybe you get, maybe you get a sense of where votes are. That would be a huge leak. Oh, we have an idea of who's voting what. Maybe, but like an opinion? 5 versus 4 for overturning Roe? I think that's where we are. The FBI and the Supreme Court are going to eat this clerk alive. $9.99 from Baraluna. Per Jonathan Peters. Consider the 1852 case Pennsylvania versus Weeing and the Belmont Bridge Company. 10 days before the court handed down the decision, New York Tribune reported the outcome. Yeah, this is what I'm saying. Like, you might have a leak that announces the outcome, but to have a leaked opinion, I'm not sure this has ever happened. $4.99 from Startup Lab. No matter which side of the issue you find yourself on, this is a hugely disturbing development. Scott's was the last bastion of institutional integrity. Damn straight. And whatever you can say about Roberts, he takes institutional legitimacy super seriously. So Roberts may be in the minority opinion on this, but Roberts is the first one who would be likely to put this person up against the wall. Because Roberts, above all, wants institutional legitimacy, to the point that he's compromising his own values potentially, as how much he wants it. So if Roberts is in the minority, Roberts himself will stamp this person to death. Beef Panda for $5. Given full faith and credit and privileges and immunities, isn't this going to open another can of worms? Abortion tourism, for example? Abortion tourism, yes. That'll definitely be a thing. $2 from a llama brat. Can this leak be used to delay the opinion? Yeah. That's quite possible now. That's totally possible. This is totally possible. I think that's opinion. There, non-authorized access, CFAA. Yeah, someone said, is it pronounced Scottus, not Scottus? Isn't it pronounced Scottus, not Scottus? Yes. And $4.99. $4.99 from non-authorized access to computer network. Yeah, maybe. From Legend News. How do I know if it's a clerk? Who else could it possibly be? There's no one else. There's no one else it could be. It has to be a clerk. It has to be a clerk. There's no one else it could possibly be. There is no one else it could possibly be. There's just no one else that's possible. Scotus? No, Scottus is fine, maybe. Scotus. Scotus? Scottus for me, baby. SCOTUS? You think SCOTUS like POTUS? Okay, SCOTUS. You want to go with SCOTUS instead of SCOTUS? SCOTUS? Sure. Either one's fine by me. SCOTUS? You want SCOTUS? Okay, we can go with SCOTUS, if you like. $5.99 from Margot Reyna. Some pundits are suggesting SCOTUS should expedite the opinion, issue 48 hours to quell the firestorm. I think your odds are better than not that they hold the opinion. I think your odds are better than not that they re-argue the opinion. They order re-argument in the fall with the new justice. Because of how pissed they're going to be. I think it is quite possible at this point you will not get a decision this year. I couldn't say for sure either way. But $9.99 from Jack Surtees. Scotus? Maybe. This is yeah, so I don't know what the Supreme Court's going to do in terms of issuing this thing or not. But I would not bank at all on this coming out this year at this point. I don't think the CFAA works here. Neither do I, incidentally. Kobe. I don't think it works here either. I don't think the CFAA works here either. I think you're right. So they mistrial it? How often are there Scottish mistrials? Never. But then again, this never happens. Then again, does it? $5 Team YouTube. How in advance are decisions made before they're released to the public? I don't know. No one knows the answer to that question. No one knows how long before they're made, before they're announced. I wonder what Nick will be talking about tonight. On his channel. Can't possibly guess. Geez, what will Nick Rakita be covering on his channel 11 o'clock? I don't know, man. Could be anything. The reporter who broke the story was a college roommate with the clerk. What's the penalties for something like this? Exile, I think. The Supreme Court will find a way to revoke their citizenship and export them to some foreign state. As punishment, would Robert fire all the clerks? Doubtful. It was only leaked because Democrats are looking for destruction in the midterms. If that's the reason, it's totally unnecessary. Without it being leaked, it would have been issued by June, and it would have been issued by the start of July anyway. It doesn't make any sense. The decision was going to come out before the midterms. The Supreme Court term ends the first day of July. I think last year they went over a little bit because of COVID, but like it ends the first day of July. There was never any possibility of this decision being held till after the midterms. You look for depressed for the person who leaked it. I didn't leak it. How would I leak it? I don't have access to this. Why would Politico even run with it? I mean, it's a great story for Politico. It's a great get. Well, the FBI is going to eat somebody alive. The leak was planned to force the court to reconsider. I don't think you're going to get anyone off on the majority who was on the majority. I don't think that's going to happen, Lee Jin. Ketanji Brown Jackson, she has no access. Jackson has no access. Four doors more Corgi. Why would this cause a mistrial of this sort when decisions after argument? Is this only the opinion of one justice? At the moment it is. And why would it cause it? Because of the institutional need. Because of the crisis. $2 from Longreach Jones. What damages if it's a justice? If it's a justice, the justice will be thrown out of office, and it will be a unbelievable reputation harm to the court. If it turns out to be a Supreme Court justice who did this, if it turns out to be like one of the left Supreme Court justices who did this, like it turns out to be Sotomayor herself, and the Democrats don't impeach her and convict her because of her allegiances, fuck me, dude. You know? How deep has our politics gone if that's what happens? Holy shit. Apparently, and unsurprisingly, there are chants outside the Supreme Court now. Surprising nobody. Yeah, Rob Price, don't worry about finding a section number. They'll find something. Am I going with Nick? What law would a person have broken? I don't know, Billy. I don't know. This is the part where I break out the U.S. code and I start looking for something. I don't know what it broke, but I'm sure it broke something. I'm sure it broke something. Give me a copy of the U.S. code and I'll find something. At this hour? Yes, at this hour. People are outside the Supreme Court. It's midnight there, and they're outside the Supreme Court chanting to nobody because there's nobody in the building. I'm not reporting on the name until it's confirmed by the Supreme Court or some other law enforcement authority. I'm not reporting on the name. But thank you for the super chat. $4.99 from Rick Haskell. Here's my $4.99 bet. Nothing ever happens to the left. See Hiller, Hunter, former FBI. Yeah, Let's go through the U.S. code now. You want to try to do a quick thing on the U.S. code? Isn't it just theft of government documents? Maybe. Do it. This is huge. Go join Nick. I'm not sure Nick wants me. Let me pop over on his stream and see what's happening real fast. Is Nick live? It doesn't look like he's live. Doesn't look like he's live at all. It's not on his channel. Is he doing a live tonight? It's not on his channel. It's not up yet at all. Well, but the stream is not even on his channel. Normally, with an upcoming live, it normally is on his channel. It's upcoming. Does he even have one scheduled for tonight? Why wouldn't he? Sometimes he doesn't do one in the nights. He doesn't do it all the time. Sometimes he skips it because he has something else to do. He's somewhere else. It happens occasionally. Call Nick. I'll text him. Hold on as I text him. Okay. He just went live. Imagine if Thomas isn't there next year. Oof, that's true. Yeah, Thomas might not be there by the time they issue an opinion. Thomas is old, man. He's been at the court the longest by far. He's old. He just went live. Let's see if he texts me back. He's streaming now? Yes, I understand. He's streaming. I just texted him to see if he wants me on or not. If he texts me back, we'll just go from there. And in the meantime, I can hang out with you guys and chat for a while if you guys have questions or whatever. Let's see if the bot is working. Nope. 18 USC 2071. Let's see what we got there. Willfully conceals, removes, or attempts to do so, carries away any record filed or deposited with any clerk or officer officer of a court or any public office shall be fined or imprisoned not more than 3 years or both. Maybe. Check your email. I think it's pretty confirmed now. I'm not reporting on it. Stephanie's here. He's doing losing. He's live. That's cool. I'm not confirming. I am not repeating the name until it's actually confirmed by, some irrelevant authority. And I don't care how good their sources at the newspaper are. I'm just not doing it. Not this time. Because it's a huge deal. And I'm not saying it until it gets absolutely confirmed. Let's see if Nick wants me over. I say Nick has it in the title. See if he sends me a link. If he does, I'm going to pour myself a drink and join him for sure. He's inviting me? Great. Well, as soon as I get the invite, I'll join over and I'll end the stream. I don't have it yet, but maybe he's sending it over in a minute. He wants to do the intro first? That's cool. I'll hang out with you guys until he sends me the link. Okay, that's cool. I'll hang out with you guys until he sends me the link. What's Nick's channel? It's called Rakita. I'll send you the link. I'll just give you the link to the actual channel. That's the link to it in a minute. Yeah. Okay, Nick wants me after the intro. That's cool. All right. As soon as he sends me the link, when he sends me the link, I'll sign off, I'll get a drink, and then we'll join him. Nick's angry because we heckled him to get you on. That's funny. He just yelled at his own chat to let him do the intro. That's funny. I gotta listen to this. Hold on. I'm putting it on my ear so I can listen to whatever he's... Stop telling me. I gotta listen to this bullshit.
Matthew Harris, which is unbreaded without the slurs. I see you a million times. Chill out. I want to do my intro before I invite anyone, okay? Can I just do my fucking intro? Oh, man.
Good times. Your analysis is gold. Can't tell you how much I appreciate your stream. You're welcome, CG715. Steven Glasker, is it possible this was leaked to force delay? I don't know. Man, good times. Touchdown. All right. I love you two as a team. Yeah, this will be an interesting one for sure. Eric 999. Kirk, did you hear Uncivil Law streaming? Oh wait, lol. Thank you for the super chat. It's appreciated. Please wear the hat. You see, I can't wear the hat and the headphones at the same time. That's the problem. I wear the headphones so his audio doesn't leak into my mic because, you know, otherwise I have to play it through the TV and then you could hear it. And I think that's a bad plan. So I can't wear the hat with the earphones. I think Nick has a pair of Shure in-ear monitors he's not using anymore. Maybe we can harass Nick into sending me his Shure in-ear monitors now that he has the ones that cost like so much money it's ridiculous. I'll clean him out with alcohol. We'll harass him into giving me his old Shure monitors because, you know, they're great. He's waiting for me to show up with drinks. I mean, you know, just to send me the link. I can't join anything till he sends me the link. 99 cents from Mr. RM. Thank you. I'm popular, I'm liberal, but agree with your take and the leak is disturbing. It's extremely disturbing. Roberts may have allowed Alito to do first draft to get lay of the land. I suppose it's possible. It just feels very unlikely. Because if I would think, even if that were true, that the opinion would be written to try to accommodate the Chief Justice, even if it was a gambit. And this is not written to accommodate the Chief Justice. If the Chief Justice was in the majority and assigned this to Alito, the opinion wouldn't read like this. I don't think it would at all. You would never get the Chief Justice's vote. There's no way that Alito gets the assignment from the Chief Justice and writes this opinion. It's just not happening. It's going to take a while. Nick is playing hard to get. Well, I don't need him anyway. Mad Cow Maddo is losing her mind over the leak. The leak is a huge deal, man. It is a huge ass deal. I don't need a drink. I'm going to need a couple drinks before this stream. Can Democrats codify Roe versus Wade? I don't know. I don't know where they would find the authority. I mean, at the federal level. At the state level, yes. On the federal level, how would you squeeze this into interstate commerce? I mean, the interstate commerce clause is broad, but it's not that broad. $4.99 from Stan Honeycutt. Holding the option would open the possibility of a makeup of the court changing and awarding the clerk's action a win. This is true. Yeah, this is a fair point. Because there's always Alito, because Thomas is old as shit, there's a possibility Thomas could die. So I think your instinct is right. I think maybe that does change the odds. Maddo's losing her mind about the leak. Let's see what Maddo's saying on her channel. This sounds hilarious. Let's watch some Rachel. Is she on the YouTubes? Can I watch her cry? Maybe I'll have to wait till tomorrow. Thomas is only like 73. Oh, I think he's older than that. How old is Justice Thomas? He is 73. Okay, well, his health hasn't been perfect, though, but he could go plots. Nick is drinking military special bourbon. That's cute. What does the timeline look like? The Supreme Court doesn't leak. So what's the timeline look like? I don't know. I don't know what the Supreme Court does. Your guess is as good as mine at this point. Maybe they hold it off. Maybe they issue it faster. If it's leaked by a justice and they're impeached, that goes to the House, Senate for trial. Yep, sure does. Goes to the Senate for a 2/3 vote, just like it would for anything else. So you need 2/3 in the Senate to convict the justice. So if it's Sotomayor, do you get the Democrats to impeach her? If they can replace her with another justice, maybe. If not, I'm definitely going to have some tequila between this stream and the next one. I'll tell you what. I mean, anything is possible at this point. Anything is possible. The FBI is going to definitely look through every clerk's computer. They're going to look through all their files. They're going to interview them all. They're going to search phone calls, probably get cell phone records, email records. What happens if a justice dies? Then you don't have the votes, now do you? Yeah, if one of the majority dies, you don't have the votes. Until they issue it, it's not final. So if a justice dies, then, no opinion. $10 from Catalan Shaw Indie Games. Thanks for reading. Glad to hear your opinion. You're welcome. If Scottus orders a re-argument, the pro-life committee will lose its mind. Well, I doubt the Supreme Court cares that much about that aspect, to be quite honest. If their only concern is the pro-life community will lose its mind, I don't think the Supreme Court cares. $4.99 from Eric. What's your take on this afternoon's witnesses in the Depp Heard case? It was pretty much a disaster for Depp today. The Q chart guy just was horrible on the damages. It was a bad day for Johnny Depp. $9.99 from Chris Disc Golferson. I'd love to see your opinion reflected in producing a LawTube Paltrick Spectrum leaning chart. I don't know if that's for me to do because I'm too close to it. All right. I think I'm going to discontinue this stream because we're kind of wrapping up here. And he's going to supposedly have me on in a minute. So I'm going to wrap up here and get a drink. You can find me, hopefully, in a minute on Nick's channel, which is the link here. I'm going to sign off for now. I'm going to get a drink and probably join Nick. Thank you all for coming for the stream. Thank you for sticking with my analysis, even the parts that you didn't like me saying, because I try to give an honest opinion always. So thanks to that. And, I'm going to sign off for now. Cheers, my friends, and goodbye.